How's jail?
It could be worse.
You're harder to get a hold of than the Pope, man. For real.
What do you mean?
You don't show up. That's what's for real.
I only showed up not one time. Just one time I missed.
That's cute.
One time.
That's cute.
Except for
Well,
the
Mr. Odom, just ask you
Here's
to
the
not
deal.
speak anymore.
You've now picked up another case. You picked up a violation of a protective order. I don't even know what happened. We're gonna figure it out. All I know is that you have an open harassment with us. While you're on bond with that one, you pick up a felony assault, and now you've picked up a violation of protective order. So, Ms. Garza, please.
Got into a physical altercation with the defendant because the defendant was drinking and becoming verbally aggressive with her. The complaining witness's older son did not like how the defendant was talking to the complaining witness and told him to back off. The complaining witness's son then hit the defendant and a physical fight broke out between the sons and defendant. Officers observed the son's knuckles be busted and blood on his shirt, and the complaining witness is the protected person on the order.
Was that from the assault or was it from the harassment?
The protective order is from the assault impeding breath.
So Judge, as you can see, my client still has visible injuries from this interaction. I would ask that the court set a bond. Mr. Odom is aware, though, that the felony court could revoke his bond, so I don't think he plans on making any bail. But we do ask that if the court would set.
I'm showing he's on bond in our case at 5,001. What, but how? Did they give him a PR bond? Did he make a surety bond? What happened here? On which case? The harassment.
I see a surety bond.
I see a surety bond on the July 1st, Judge, on the harassment. 5,001.
It's weird because it just doesn't.
Financial casualty and surety.
Okay. I want you to know, Mr. Odom, that no means no. I don't care what your excuse is. I don't care what you're doing in life. The Texas Constitution does not allow me, but in extremely limited circumstances, to hold someone at no bond, zero bond. This is one of those occasions. Ma'am, take a seat, please.
Yes, sir. Sorry.
If you are charged with a violation of a protective order, and I put conditions on that violation, and you violate those conditions that I put on you on the VPO, I can have a hearing to hold you at no bond. Mr. Odom, I want you to know that I'm going to do that in a heartbeat. And I will do everything in my power to protect every single person in Harris County.
Yes, sir.
Do you understand?
Yes, sir.
I'm ordering you as a condition of your bond not to have any contact with any of the complaining witnesses in either the harassment or the violation case, or I'm sorry, the impeding breath case, not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to put a scram ankle monitor on you. Remember this, man. These conditions will all go on the violation of a protective order. If you consume alcohol, I can have a hearing to hold you at no bond. If you get this scram device and you don't charge it, I can have a hearing to hold you at no bond. I'm going to put a GPS monitor. I'm going to give you a curfew and a 1,000-foot exclusion zone from the house in question. If you go anywhere near it, I will have a hearing to hold you at zero bond, and that's what I'm going to do.
Yes, sir.
So, Tracy, he must have a GPS monitor prior to release. I need to make sure that he signs the conditions today. I don't want it to fall through the loop. So we'll have one day upon release, he must get a scram ankle monitor. No weapons, no contact with any of the complaining witnesses, no going within 1,000 feet. You must charge both of these monitors on a daily basis. If they die, so do you. Do you understand?
Sure.
I'm gonna set your bond on the violation of protective order at 10,003. You have a cell phone.
I don't.
How is it that the lawyer can get in contact with you?
The only person that I had was her, my wife. It's the only person. I have a phone, but it's not connected.
How do you get in contact with people?
I use her phone.
You can't use this person's phone, dude.
I know, I don't have a phone right now, not until I get out. I can't do nothing while I'm in jail.
What do you do in life, man?
Oh, right now I'm in jail, so I mean, I'm not doing anything.
What were you doing?
I was a mechanic.
Jillian, I don't know how you're gonna get a hold of Mr. Odom. Smoke signal. You have an email address. Mr. Odom,
He is aware his felony court date is just next week. And the previous misdemeanor is the day after. So if he were to bond out, I have a note to go up there and just see. I don't think he will, but if he does,
I mean,
I can go.
Jillian, he's made bond on the felony impeding. He's made bond already on the harassment. He must have some kind of lucky charm out there. It's magically delicious that makes all of his bonds. So, you know, it's a matter of time. They're going to make this bond if you don't remain in contact with your lawyer.
I can't bond out. I'm not bonding out until I go to felony court.
Someone's made both of your bonds here.
Well, she has, but I'm not one talking to her. She told me not to call them.
If you bond out, you must remain in contact with your lawyer, Ms. Hawkins. I'm gonna give you a piece of paper today with her phone number. Either commit it to memory, do whatever you need to do. Mr. Odom, I promise you, I will have a hearing to hold you at no bond if you don't follow these conditions. I'm not asking much.
Yes, sir.
All I want is the streets to be safe. Do you
Yes, sir.
understand?
Yes, sir.
Okay.
How you doing today, Young?
Not happy with you?
Yes, sir, I understand.
We'll get to it. Everyone, keep it down, please. Mr. White, you are now stand charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you.
Judge, on July 21st, officers were dispatched to a family assault call in Harris County, Texas. Officers met with the complainant, who is the defendant's stepfather. The complainant stated that after telling the defendant to turn off the defendant's mother's vehicle and come back inside the home, the defendant kicked open the front door and punched him with a closed fist to the left side of his head. The complainant stated that the defendant then fled the scene in his vehicle. The complainant stated that the defendant has been staying in his residence for the past 2 weeks due to not having anywhere to stay. The complainant stated he felt pain when assaulted and wanted to pursue criminal charges against the defendant. The complainant had visible minor injuries near his left ear.
Mr. White, I'm going to find that there's probable cause to go forward with your case. I'm entering in what's called a magistrate's order for emergency protection. This is a court order that identifies Mark Maple as a protected individual. You cannot commit family violence or an assault against this person. Commit an act in furtherance of an offense under section 42.072 of the Texas Penal Code, which is the stalking statute. You cannot threaten, harass, use another person to communicate a threat or harassing behavior. You cannot be in possession of a weapon or go within 200 feet of where he lives or where he works. Do you understand?
Yes, sir.
Now, I'm also, as a condition of your bond, ordering you not to consume alcohol or illegal drugs. I'm going to randomly test you. If I find that you're consuming alcohol or dope, likewise, your bond will be revoked. You will go into custody. As it stands now, you are on bond for at least 4 to 5 other cases. One of those being an evading arrest here, which is 1,200 days old. I am now revoking that bond and taking you into custody. He goes with you. Josh.
Yes, Your Honor.
All right, good morning, Mr. West.
Mr. White.
Mr. White, I don't know why I keep saying that.
Morning, Young.
Good morning, Mr. White. So, sir, you have with us the assault. You also have the evading arrest. Tell me, what are we doing?
My understanding is that we're dismissing the new assault and that he's doing time served on
The gun case?
I believe it's an evading.
Yeah, you're right. It's an evading, correct, right. So, Mr. White, you're charged with 2 cases. You're charged with evading arrest. You're also charged with assault of a family member. Both of those are Class A misdemeanors. You're facing up to a year in jail and or a $4,000 fine. You've worked out an agreement, a very great agreement where they're going to dismiss the assault in exchange for your plea on the evading. Understand that the evading is an enhanceable offense. This one will go on your record. If you ever run from the cops again, evade, you will be looking at another felony charge. And with all your priors, they can continue to enhance you probably to a third degree, probably to a second degree. Just running from the cops, you could be looking at up to 20 years in prison. You understand?
Yes, sir.
You give up a lot of rights by entering into this agreement. You give up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. So once you accept this agreement today, you can never come back and change this or undo this.
Yes, sir.
Is this what you want to do?
Yes, sir.
How do you plead to the offense of evading arrest? Guilty or not guilty?
Guilty.
I will find you guilty, sentence you to 16 days in jail. I will give you credit for the 16 days that you've done. I will roll your court costs so you won't owe anything. And good luck to you, sir.
Yes, sir.
All right. Thanks, Josh. Take care. You too.